Today we're going to talk about causes of action. I'm going to get into Title 18, but first I wanted to let you know about a piece of technology that may be used against you. It's called a Stingray. It's like a device that can fit in a backpack. It's a mobile cell phone tower, essentially, that will knock out the connection between a person's device and their cell phone tower, pretend to be that cell phone tower, and connect to it, effectively monitoring all of the communications going in and out of that device. And I think the capacity is right around 160,000 cell phones at a time that this thing is able to do, and unfortunately we cannot trust that it is exclusively law enforcement operating these devices anymore, because you can get them pretty cheaply, and that is a bummer. So we're going to just be vigilant in the communications that we are using, and if we're not causing loss, injury, or harm with our communications, then we just have people who are spying on it to be abusive over things that have nothing to do with them, right? But we do want to remain vigilant. We do need to know what is possible out there, and so yes, stingrays are a possible thing that can be used against us. So be careful about that. My Wi-Fi is up and running, so let's jump in.
It said Title 18. This would be Title 18 of the United States Code, and specifically where we're headed is sections 241 and 242. So that's how I format it in a search. And then I like to go to Cornell Law, so we'll do that. 18 U.S. Code, section sign, that's what that is. It means section sign. 242, and this is deprivation of rights under color of law. As with everything in law, it is wordy, so hear me out or buckle up in just a moment here. Whoever under color of any law, which is something that's not law but is practiced as though it is law, so it's under what's called color of law. So this would be like a policy of a private corporation. It would be practiced under color of any law. Statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights. So whoever, under color of law, subjects any person in any state to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race, then are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year or both. Okay, so if they are causing you loss, injury, or harm, or depriving your rights, privileges, or immunity, secured or protected by the Constitution or the laws of the United States, or if they're just disproportionately punishing you to different punishments based on you being a certain race or color or your national origin, other than those punishments prescribed for the punishments of citizens, well, then they're going to be fined or imprisoned for more than 1 year, not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, so like a police officer having a weapon on their hip, explosives or fire, shall be fined under this title or imprisoned not more than 10 years or both. So if it's a police officer carrying a weapon, firearm, that's 10 years. And if death results from the acts committed in violation of this section, or if acts include kidnapping, so a false arrest, being dragged into jail prior to conviction, and kidnapping really constitutes you being moved any direction without your consent. And so if you're put in torture cuffs and placed in a cruiser and taken to jail, that's called kidnapping. And without due process, that's called kidnapping. Or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death. Okay? So if an officer unlawfully arrests you, they may be sentenced to death, and that is how the rule of this law is written. So that's just if one person does it. However, let's see, we're going to go into section 241. This is the conspiracy against rights. And so this would be if two or more persons conspire to injure, oppress, threaten, or intimidate any person in the free exercise of the enjoyment of any right or privilege secured to him by the Constitution or laws of the United States. So like your ability to travel freely, yes, that is a right. Or because and it does include the right to travel in the modern conveyances of the day, meaning a automobile. So you can travel but you can walk. No, that's not correct, and it's not how the law is written. So if two or more persons go in disguise on the highway, meaning if they are going to go appearing as police officers on the highway, or it's known as a street, they just use the word highway, they're synonymous terms, or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any rights of travel, right, or privilege so secured, or employment, right? So if you're traveling just to go to your place of employment, that would be also a prevention or a hindering of your free exercise or enjoyment of a right to be employed. So they shall be fined under this title or imprisoned not more than 10 years or both, and if death results of this action, or if such actions include kidnapping, so if it's a false arrest and wrongful imprisonment, right, then they shall be fined under this title or imprisoned for any terms of life or both, or may be sentenced to death. So this conspiracy that may or may not be forming around you, good luck proving that your coworkers are part of a conspiracy that's performing performing discovery for the prosecutor of your case. I mean, good luck with anything like that, or proving that your family is helping them to, or whatnot. Okay, but you do have proof that there is a conspiracy to deprive a person of their rights because of the paperwork that's being submitted by the police officers and by the prosecutor and then the judge. That would be a conspiracy to deprive you of your rights under color of law, as they are submitting you to a quasi-criminal jurisdiction of fiction in order to perform what's called a legal simulation on you, which has to be addressed. Okay, so that's Title 18. Unfortunately, though, these are not causes of action that we are allowed to bring in a federal venue, because they are Title 18, which is the crime and criminal procedure section, and we are not federal prosecutors. We do not work for the government, which is their abilities to, those causes of action are reserved for them. Whether or not they're bringing charges against us under the false belief that we are working for government or not, we are not going to be using Title 18 as our cause of action. We'll go down to Title 42. Here, just a second. We'll go to Section 21. This is civil rights. And we're going to go down to 1983. So we'll just look at subchapter 1 for the generality. 1983 is a civil action for deprivation of rights. And this would be every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory within the District of Columbia, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to deprivation of any rights, privileges, or immunities secured by the Constitution and law, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or a declaratory relief was unavailable. So we can't be suing people in their judicial capacity. What we're doing is we're suing them in their personal capacity for acting outside the scope of their official capacity. So abusing their power as an official, we sue them in their private capacity, is the cause of action that we can bring. One thing I do want to mention, though, is improper training. In Monell lawsuit as a search, and I'm just going to this website that I've never seen before. We'll check it out. Okay, so the introduction states that in most Section 1983 lawsuits, the individual actors who committed the alleged constitutional violations are the named defendants. But in many suits, the municipal entity, so the city, is brought in as well. Local government entities, as long as they are not the state or an arm of the state, can be sued under Section 1983 for damages and injunctive relief. You can sue the city. So plaintiffs generally use one of 4 methods to establish municipal liability. I'll let you jump into this, but it's digital commons was the thing. Tourlaw.edu. Main thing I wanted to mention about Monell lawsuit is the case of Monell versus New York City Department of Social Services. Here's your citation. Established that governments could be persons as well under the language of Section 1983, meaning you can sue government. The court clarified, however, that such liability could not be based on a respondent superior basis. Instead, for liability to attach against a government entity, the federal claim, which is what that is, it's the cause of action in a federal venue, must have resulted from a policy or custom of the government that was the moving force behind the violation. So the policy of improper training could be, this is their official policy of how they train their folks. You know, we arrest you and we take you to jail prior to conviction, and that's how we actually have it stated in our training handbook. Okay, well, that's called improper training. Well, it doesn't have to be a policy. It can be a widely adopted custom, and it still counts as improper training. Now, the thing with improper training is we want our police to be well informed, right, and to have some understanding of what their charges are and who they apply to, and they can't just willy-nilly apply charges to whoever they see fit. They do need to have some level of training, but failure to follow training isn't a Monell claim. So I know that was a lot, and I hope that was helpful. Again, these aren't causes of action that we're bringing. The cause of action would be the 1983. I hope this was helpful. I'd say that we have effectively covered our groundwork, our base layer, our bedrock, our Section 101. We're now able to move into Dr. Graves' course at howtowinincourt.com with much more awareness that will help us. But anybody can jump in on that, and again, I will help you obtain that course, and we're going to go through his framework, but all glory to God and all praise to God. But Dr. Graves has been doing this for many decades, and so we're going to go off of his framework. It's not mine, it is his, and I encourage you to buy that course. I'll help you get that course if you can't afford it, okay? And we'll go into that, and our very next video, we'll begin talking about that. We'll talk about the forms of affidavit, and we'll show how all the paper is going to be done. But we do need to have this comprehension of what certain things are so we can implement them into the framework that's coming up. All right, have a great and wonderful day, and God bless you. Take care.